So good morning, Jack, or almost morning, right on the cusp. And we are going to talk today about, I think, the Supreme Court order that came down yesterday within the overall context of how commentators have been judging the court's performance on the so-called shadow or emergency docket. You have a piece up this morning in which you sort of assess the court's performance to date, and particularly against some suggestions that it has been cowing to the Trump administration, or alternatively, either in doing so or otherwise, taking some new approach, departing from what it might otherwise do to successfully discharge its responsibilities. So why don't we begin with your basically providing an overview of what it is that you have in your post?
Sure. Thanks, Bob. So I heard from three smart journalist friends earlier this week, who asked me in various ways, why isn't the Supreme Court standing up to the Trump administration? And this judgment, I don't know quite what it was based on, but it's based, at that point there were five, now there are six emergency orders that the court has issued. And my basic piece is about why it is extremely premature and not justified to say that at this point the court is cowering to the Trump administration. So let me just briefly say what emergency orders are, and then Adam Liptak, who's the Supreme Court reporter for the New York Times, a fine reporter, had a piece that I think was the basis for some of these questions I got, in which he suggested, as you said, that the court was going in a new direction, and that instead of the bold decisions it had made in the past on cases like abortion and the like, that here, to use his language, that the court in the Trump cases have been issuing a series of narrow and legalistic rulings that seem calculated to avoid the larger issues presented by a president rapidly working to expand power and reshape the government. Liptak called this a new approach that was designed to avoid a showdown with the president. And so I just think that's the wrong way to characterize this. And let me explain why. And for some of the reasons that Liptak says later in his piece, to be sure. So these cases are not cases these are cases, all of the cases that have come to the court. For example, the case last night about the man who was unlawfully removed from the United States, the case involving the Venezuela deportations, there was an education case and a few more. These are all cases, it's very important to understand, that are at the very beginning of the lawsuit, at the trial level with a preliminary ruling. And the only thing that the court is ruling on is called an emergency order. They're not giving a ruling on the merits. The Supreme Court normally addresses cases in full after a trial, after an appeal to the Court of Appeals, and then to the Supreme Court. These and the sweeping cases that Liptak was talking about was that posture. In this context, the court is dealing with an emergency order where it's just as we've discussed before, it's just setting the baseline about how the case should proceed from the beginning in terms of whether the government's order or action can continue temporarily during the trial and appeal, or whether it can't continue. And this so-called shadow docket is not a place for grand rulings. It's a place for narrow rulings, and you're not supposed to make pronouncements on the merits. And the reason is there's no oral argument, there's no briefing, and the like. So I explain that in the piece. I go through the six emergency orders to date, and I do a little back of the envelope calculation of wins and losses, and basically say that, the government has won a few and lost one or two, and there are split decisions, and there's just no way you could say that the court was cowering in this, especially in this procedural context. And then at the end, I talked about a little bit more about the shadow docket, about all the tools the court has, about the difficult position it's in, and about how it's really, I think, trying to kind of set up these cases so that they can be decided either by the Supreme Court or the lower courts in the best possible light after full information.
And you use the term temporizing. You say the court's approach is one of temporizing. Can you elaborate on that a little bit?
Sure. I mean, I wrote a piece on executive functions a few weeks ago where I theorized or speculated that the first two decisions were temporizing. And basically, what I mean by temporizing is the court is going slow and trying to take an action now that will give itself an advantage later. In other words, this is akin to Alexander Bickle's passive virtues, where the court tries to exercise discretionary decision making to kind of set up the case so it can be better resolved later. And so it can avoid being unduly and prematurely drawn into the merits of these cases. And I think that's what often happens in high profile cases on the shadow docket. And I kind of think that's what's happening here. And I go through and give some other examples.
So in short, it's doing this, but not in a way that is a radical departure from its use of the shadow docket in the past.
Not at all. I mean, there have been some disagreements about some of the decisions, especially the Venezuelan deportation decision. Um, and one can disagree about these orders. And I really want to emphasize that none of these big orders yet say anything about how the case is ultimately resolved. Many of these decisions are just about which court it has to go to. And there's nothing untoward at all about what the court's been doing on its shadow docket as far as the type of decision making it's making. This is, again, there have been commentator disagreements about particular decisions and about how decisions should be characterized, but that's normal science, as is what the court's been doing on this docket. It's not, it just can't be construed as not standing up to the president. We're not at that stage yet. And it would be, last thing I'll say here, it would be deeply imprudent for the court in the shadow dock. I mean, we can talk about last night's case in Nome versus Garcia, where the court did, in a unanimous decision, was fairly firm on some what you might call procedural points, but it would be crazy for the court to have a massive confrontation on the merits with the Trump administration in these very preliminary cases. It's just not appropriate.
Let's talk then about the Nome versus Garcia case for a second. So there's some disagreement. I suppose most commentators, basically as if this morning's count, if there ever could be a full count on commentating, most commentators see it as a loss for the government on balance.
Yeah.
But there's some disagreement. So for that reason, you characterize it as a split decision.
Yeah.
Can you talk a little bit about what are the pros and cons in making that assessment?
So, yeah, okay, I'll explain that. So basically, this was a man who was deported by the United States, and what the United States admitted was a mistake. I think they called it an administrative error. And it appears that the government, despite acknowledging that mistake, has taken zero steps to try to bring him back. The district court issued an order. I don't have the language in front of me, but basically, here's the language. The district court order had directed the government to facilitate and effectuate the return of Abrego Garcia. That was the language, to facilitate and effectuate his return. And then there was a question in the Court of Appeals stay proceedings about what it meant to facilitate and effectuate. And so this, and the court was asked, the Supreme Court was asked to vacate this decision. The government applied to vacate the decision. And to make a long story short, without getting into the technicalities, the court basically retained the essence of the district court order. And then it asked the district court to clarify its order. It said that the essence of the order was to facilitate his release, and the Supreme Court directed the district court to clarify what effectuate means and to give due regard and deference to the executive branches in the conduct of foreign affairs. Basically, the reason people thought this was a loss for the government is the government argued essentially in its application before the court that courts couldn't do anything here. This person is outside the United States. You can't direct the executive branch to bring him back. 9 justices, it was unanimous, rejected that proposition. That's why most people see it as a loss for the government. The reason I treated it as a quote unquote split decision in calculating or in kind of analyzing these cases is to show that the court wasn't cowering. I wanted to bend over backwards and give the Trump administration's views the benefit of the doubt. And 2, the court did say that the executive had to get deference and that it didn't tell us what effectuate meant. So we still don't know what the court ultimately thinks about what the president's duties are. And we do know that the court thinks the president gets some deference. And of course, the Justice Department was trumpeting that part of the decision completely misleadingly last night. So the question, it's not clear what happens from here. I mean, I think it definitely is not what the government wanted, but it didn't give the petitioner everything either.
So it would be fair. I don't want to overstate the case, but it would be fair to say that, in some respects, what people might focus on and thinking about how the court's dealing with the Trump administration is that in two cases, the Alien Enemies Act and this one, Noam versus Garcia, 9 justices took a stand on due process issues, 9 unanimously in both cases. In the first case, basically saying there has to be notice and an opportunity to be heard on the part of any one of these Venezuelan deportees. And in this case, again, holding the government accountable in the described respects, although leaving it up to the district court now to be a little bit more specific in its ruling on that. So that seems like pretty strong medicine for the administration, given the position it's taken to swallow.
Yeah, so that's extremely well put. And again, I want to emphasize these are not full blown opinions. These are little orders that are sometimes a paragraph, sometimes a page, sometimes 2 pages. But what you just said is accurate and really remarkable. And it's the court nudging the Trump administration to try to do the right thing before there's a full-blown confrontation. We saw this in the first Trump term with the Trump versus Hawaii case, where the court, through its emergency orders, basically nudged the Trump administration into finally, in its third try, crafting an order that was lawful. You know, putting it there are other things in those cases going in the government's favor, but those are really strong points. And they both highlight the extremity of the Trump administration position. And they indicate that to say that the court is cowering on the emergency orders docket when it's not deciding much, and in fact, it decided quite a lot along the lines you just said, it's just a completely misleading impression.
So maybe we could just briefly turn to speaking of the courts and the law and the lawyers who,
Yeah,
before the court,
there was a story today in the Times about more firms about to cave, I think.
yes, it was a story yesterday in which 3 firms were named who in the top 20 who are apparently negotiating for settlements along the lines that were reached by Paul Weiss and Skadden, Milbank, Willkie Farr. So there's you might say, something of a critical mass beginning to develop in the top 20 law firms, firms that are actually looking to resolve these issues by negotiation. And the price may be going up a little bit. Stephen Miller in this piece is saying they're getting close to $1 billion in pro bono commitments for what the administration wants to believe are their causes. And we'll see what the numbers look like if these settlements are actually reached. Meanwhile, Donald Trump himself is putting his own, interpretation with whatever justification on what these pro bono commitments amount to. He's saying that he's looking forward to their help on trade deals. I think he said something about their assistance with representing coal industry interests. I don't know whether he's just rubbing it in or he's fantasizing or what it is, but it looks like the top 20 firms are going to be heavily represented on the settlement side of this controversy.
And what do you make of this? What are we to make of this?
So there's still some resistance, I should mention. An executive order was issued against the law firm of Sussman Godfrey, notable, by the way, for having represented Dominion voting machines against the attacks that the administration had, or excuse me.
Do you know if that was mentioned in the executive order? Or I didn't read it.
I don't believe that it was. I don't believe that it was, as I recall. But it's clearly going to fight. So you have another firm, now it's 4 total, that are going to resist these executive orders in courts, challenge them. But I think that this breakdown between firms in the top 20, top 50, I suppose is more in the top 20 that I think this accounting has taken place, that are looking for settlements, and other firms that are prepared to resist, that breakdown is becoming more and more apparent. And so for those who think it's a dollars and cents judgment on the part of firms that are seeking to settle, they're highly resourced, they're very profitable, they don't want to risk in any meaningful way their current economic position, then they give a lot of credence to the suggestion this is just a dollars and cents business decision, rather than one that takes into account all the professional obligations we expect lawyers to discharge. So I think on the whole, in answer to your question, I think it's sort of a catastrophe for the profession.
Is it fair to say, is this the right way to think about it? Every one of these big firms that settle makes it that much harder for the next firm to litigate. I mean, I think as you see more and more firms settling, the cost of litigation probably goes up because you're seeing you have a kind of growing cadre of safe firms that certain clients can go to, which puts pressure on the firms that are litigating to kind of absorb the costs more directly of what the government's doing. Is that fair?
Yes, I think that certainly as firms start to settle, prominent firms begin to settle, it has to put a lot of pressure on firms, at least in this respect. There will be lawyers within the firms that haven't settled that think they will be a target, who are going to say, why are we separating ourselves out in this way? We're putting ourselves at an enormous disadvantage, and we're separating ourselves from really fine law firms that are nonetheless settling. Why are we not at least having these conversations with the administration? So I think it is a problem for the firms that remain out there who haven't reached a resolution on this.
Yeah. And the last thing I have to say about this is to just remark that among the hundred and some odd, however many executive orders and directives of the Trump administration, in terms of clear illegality, this is near the top of the list, if not at the top. I have a small list at the very top. There are a lot. It goes pretty deep, but at the very top of clear illegality are these cases. There's no basis. There's no way that, in my view, that this can be made consistent with the First Amendment. So it's really just a remarkable thing that the federal government is basically engaged in extortion on an illegal basis against the major law firms in the country, and they're caving. I mean, it's not what did not have that one on my card on January 20.
No, I didn't either. And I'll just add this: not only would any lawyer who's looking at this fairly agree with you entirely about the illegality, but the courts that have weighed in so far have been very clear that they view it as illegal, and the administration is continuing to do it. It's continuing to issue executive orders that it did against Sussman Godfrey. It's continuing to try to extort these settlements. It's really quite extraordinary.
And let me say one more thing. I noted in my piece this morning, and I believe this is right, that the court, even in the cases that have where the law firms have been enjoined, the administration has not sought emergency order relief in those cases because it basically, I think, has no basis for emergency relief. There's no likelihood of success on the merits, and the irreparable harm all runs to the firms. But this just highlights, I think, that the government thinks it's winning even when it's losing on the preliminary injunction. It's still bringing enormous pressure on these firms. So why does it care? Why does it need to seek emergency relief from these injunctions? Because it still is putting pressure on the firms that are litigating, and it's still getting the benefits vis-a-vis the firms that aren't litigating. So it's just a really remarkable situation.
And I'll just close with this thought. Let me know whether you disagree with this. The fact that the administration is proceeding in the way you just described is just another example of something you and I have talked about time and again, which is it's a horrible look for this administration, and it cannot help the administration's posture before the judiciary, even in other cases. This willingness to just carve out this path and insist on it, knowing it's an illegal path, in the face of court orders and or decisions that make it also clear the courts agree that it's an illegal path, is a very bad position for this administration to be in, and I think it will pay a price for it.
We've been speculating about that, and it remains to be seen, and we probably won't be able to see actually when it happens. But I will say there have been many, many contexts where the administration has acted this way, where one would have think, and indeed we've written, that this cannot put them in good stead in courts. They clearly don't care. And they just clearly don't care. That is not part of their decision calculus. So, and I've been speculating about this for 2 months now. What is the decision calculus? Do they not think, in fact, it's going to hurt them in court? Do they not care what courts do because they're winning anyway? Do they plan to defy courts? It's a mystery to me. It's not clear there is a strategy other than win in the short term, but it is, again, a remarkable thing.
Agreed. Well, I guess we can end on that note.
Have a nice weekend.
You too. Take care.